As it turns out, people far smarter than I am have already been working on and proposing solutions to address the problem of animals being considered property in our legal system. So instead of trying to come up with something that hasn't already been considered and written upon, I surveyed the research and the current literature that addresses this issue and picked out the models that I think would work best. We know from both research and personal experience that animals are sentient beings. They have the capacity of a wide range of emotions and feel pain, form connections both to humans, to each other, and to animals of other species. And they demonstrate sadness, happiness, loyalty, confusion. Laws are meant to represent the morals and standards. Laws are meant to represent the morals, values, and standards of that society. And laws governing animals fall short of this in the United States when considering them property. As Alan Watson noted, when animals are regarded as property, adequate legal protection is impossible. Children were, until only relatively recently, considered the property of their parents. In fact, under English common law, children were considered the chattel of their fathers, and as such, fathers could decide to do whatever he wanted with the child, including terminate the child's life. Yet, as Barbara Bennett Woodhouse points out, common law rights, what the fuck is my problem? Common law rights, as Barbara Bennett Woodhouse points out, common law rights, although firmly rooted in tradition and necessary to maintenance of the traditional order, often reinforce inequalities of power and justify the oppression of the weaker by the stronger. This potential of the common law to make abuse and exploitation seem ordinary and natural means that we must treat rights rooted in the common law with heightened suspicion rather than heightened respect. Child custody cases often refer to children's interests, not their rights, whereas the legal standard remains the best interest of the child, and the best interest of the child standard prevails. David Faber suggests a legal construct that models the caretaker or legal title holder of an animal must assume a role designed for the intellectual, sentient level at which the animal functions, while the animal holds equitable title to himself. Courts already and often use the substituted judgment concept to explain a role of those who make decisions for others who are unable to do so for themselves. There is no legal or logical reason the same model cannot be applied to those who care for companion animals and even those used in research, farming, and wild animals. David Faber states that connection should be viewed by the law more like the custodial relationship between parent and child, and less like ownership of an inanimate object that has no self. Just as the parent of the child must sort out what is in the best interest of the child, so the animal guardian must decide what is the best interest of the self-owned animal. Indeed, guardians and conservators exist to protect the rights of others' interests, a legal concept that is familiar and traditional. David Faber also states that it is possible to imagine and articulate a legal paradigm in which a non-human animal has equitable self-ownership and thus states within. David Faber also points out that it is possible to imagine and articulate a legal paradigm in which a non-human animal has equitable self-ownership, and thus status within the legal system, while a human retains legal title to the animal in question. Professor Favor proposes an intermediate ground between being only property and being freed of property status, where the interests of animals are recognized by the legal system, but the framework of property law is still used for limited purposes. Such changes, he says, will affect how humans consider and relate to the animals in question, and the duties owed to the self-owned animal will arise out of two primary legal sources: anti-cruelty laws and the concepts developed for defining the parent-child relationship. Professor Favor again points out that animals are not humans and are not inanimate objects. Presently, the law only has two clearly separated categories: property and juristic persons. But it is possible to construct a new paradigm that gives animals the status of juristic persons without entirely severing the concept of property ownership. This solution envisions a separation of titles by accepted legal procedure. The split can be accomplished by one of two methods. First, by private lawsuits brought by existing owners, which transfers the equitable title to the animal itself. And second, by judicial or legislative action granting animals equitable title in themselves. Another comparison of legal protection is offered by Stephen Wise, who points out that U.S. courts generally hold that incompetent human beings are entitled to the same dignity rights as are competent human beings. Wise argues that other humans who cannot protect their own rights, such as those in a persistent vegetative state and infants, are given rights under the law, and then it follows logically that courts must do the same. Courts would have to recognize that non-human animals who possess capacities for autonomy and self-determination of similar degree, or their equivalents, also possess a dignity sufficient to trigger a realistic and non-arbitrary degree of dignity rights as well. Wise also argues that the important part of legal personhood turns not upon species Wise also argues that the important part of legal personhood turns not upon species membership, but upon the possession of important qualities. And it's clear that many animals possess attributes similar to those of humans. So the fact that the framers of the Constitution did not know these facts does not render our modern understanding unfaithful to their essential objectives. Wise states that the reason that an exceedingly small number of decisions actually have sought to justify the status of non-human animals as human property is that judges normally fail to perceive that it requires justification. As human slavery once was, legal thinghood of non-human animals is accepted as a first principle. Luckily, though, that is starting to change, and more people realize through both scientific research and their own experiences, mostly with their companion animals, that animals are much less a thing and much closer. Animals are much less a thing and are much closer to human qualities than the law recognizes. Particularly because corporations and ships are also deemed legal persons in some situations, making clear that being a human is not required to being a legal person. Therefore, if this model can be legally conceptualized, there's no justification for not including animals who are undoubtedly closer to humans than ships and corporate entities. Excuse me. In some states, tort claims can be brought on behalf of fetuses alleging injury. A fetus born alive can sue for prenatal pre-viability injury. Common law has even allowed a fetus that never existed outside of the womb to bring a wrongful death case and a homicide case. The law recognizes that potential humans dwell in a place between property and person, which indicates that the law is capable of recognizing such a category and animals should be included. Carol Matlack is one who suggests a category of property called sentient property, which would describe certain animals to be in this hybrid category between person and property. She explains that sentient property status would apply to any warm-blooded, domesticated, non-human animal dependent on one or more humans for food, water, shelter, veterinary care, or compassion, and typically kept in or near the household of its owner, guardian, or keeper. The problem with this model is that because the word domesticated is involved, it would not cover, most likely, animals in research, in the wild animals in captivity, and possibly even farmed animals. So I believe this categorization is too narrow, and Carol Matlack's definition of sentient property is not the best model, but it would still serve as a starting point, if that's the best we could get, for pushing the common law forward to include other types of animals in eliminating the property status of other types of animals. Thomas Kelch believes that common law may actually be the most effective way to change animals' legal status, so opposite of Barbara Woodhouse. And he states that a fresh judicial view of the status of animals is perhaps the best means presently available to change the legal view of animals as property, given that legislative efforts to protect interests of animals have largely been ineffective. I believe that taking all of these approaches and continuing with efforts to push the common law to change the property status of animals, while simultaneously lobbying for legislation to be written that gives animals a definitive right that changes their status in the law, and even amending the Constitution so that it becomes nationwide instead of left to various states, is the best approach, though far-fetched. Doesn't mean we shouldn't try. So that's all I have, Brittany. Hope that's good. Love you. Thank you. Let me know if I should do this again.